SJC-12160, Christy Coe v. Commissioner of Probation and another.
Thank you.
Ms. Eisenberg, good morning.
Good morning, Chief Justice Gans and honorable justices. My name is Beth Eisenberg. I represent Christy Coe, and with me is Catherine Hinton, who is co-counsel in this appeal. Christy Coe committed her only sex offenses 26 and a half years ago. Beginning with her imprisonment and probationary terms for these offenses, she worked so doggedly, so hard, and so devotedly to rehabilitate herself, as is evident in the record that we've provided to this court, over the next 20 years, that in 2015, which was 12 years after the Sex Offender Registry Board finally classified her as a Level 2 offender, the SORB itself, the agency that is tasked with the obligation to assess risk of reoffense to the public, determined that she no longer presented any cognizable risk of reoffending or any danger to the public, and they released her from her jurisdiction. From their jurisdiction. She was done. This court said squarely in Commonwealth versus Pond that rehabilitation of this kind by an ex-offender so that they can find a place to live and they can have a job to work at is a compelling interest of the government and not just of the individual. But even though her sex offenses are now over 26 years old, and even though she has rehabilitated herself so thoroughly that SORB itself saw no further reason to obligate her to register for what was otherwise a lifetime registrable offense, Christy Coe cannot ever be heard on whether she should be entitled to seal her historical sex offense.
Could you go back
convictions.
to the Pond case for a moment, please?
Yes.
Because that's conviction sealing. So what would you say about the balancing issue here, where we have an offense that is one that resulted at one point in time of a Level 2 sex offense as opposed to a non-conviction sealing?
Well, first I would say that in Pond, the court's observations about the compelling government interest, in my recollection, was an observation that the court made generally with respect to the importance of the passage of the new Corey Act, that these considerations were not confined to the particular plaintiff before them in that case, but generally the court's observations that this is why the law was changed. With respect to the government's interest in this case, I think what one has to look at, what the Supreme Court says is, you determine what is the substantive right that is implicated by the implementation of the law.
And that here is the liberty interest?
And that here is liberty and privacy interest. Now, the liberty and privacy interests in this case are flow from both the ability to find gainful employment and the ability to reside in a safe, affordable, decent housing without the stigma attached of trying to obtain these blessings of liberty without being so disadvantaged by one's history that the premier agency in this Commonwealth has essentially said is no longer relevant
What
to
do you
this
say
individual's.
about the Commonwealth's argument that she does get to show to whomever has access to her Corey information that she's rehabilitated and she's trustworthy and all of that? Is that realistic?
I think it is not. We actually addressed this in our reply brief. I think, number one, it evades the more profound question of whether these individuals should have her record at all. And it brings us back to the question of what is the government's interest in, if not actively, this is a little different than the registration cases where information may be actively disseminated. This is by not suppressing information that other individuals in other classes are entitled to not have revealed, are entitled to seal in perpetuity. So I think the fact that she may be able to, quote unquote, mitigate or present relevant evidence to this employer or to that landlord doesn't really get to the question here of why this statute should be applied to her without benefit of a hearing. And I also think that, as is set out in our affidavits, and it's totally uncontroverted, it's one thing to have a policy where an agency can say, well, I'm going to go through I don't think this person is eligible for this job based on their query, but I'm going to look at other relevant factors and perform this test because the DCJIS has.
Can I ask you, she has a very compelling story, and this conviction is quite old, and extraordinarily, she obtained the relief from SORB and then from 2 Superior Court judges. Does this really speak to an as-applied due process violation in her case?
It is an absolute as-applied. We have not made any challenges. Now, it may be that one day down the line, that challenge will present itself to this court. But for today, our claim is that as applied to Christy Coe, this law is constitutionally deficient because it makes presumptions without allowing her to address by way of hearing that those presumptions don't fit whatever the objective of the legislation is. And the
But what about
objective
your equal protection argument, and also what about the unconstitutionally retroactive?
Right.
Aren't
And
those more than as applied arguments?
no, they're as applied. We were very careful to make all of our challenges in this case as applied. I concede that, my equal protection argument, I reread it last week, and I sort of got into the weeds a little bit. But I do think that it's clear that what we have to say for purposes of equal protection is this statute is over-inclusive because it includes, over-inclusive as applied, because it includes Christy Coe. And Christy Coe, her profile is such, her presentation of her rehabilitation is so complete that really there's no legitimate governmental objective in keeping her from being able to accomplish these goals.
So help me to sort this out. What if there were no statute which authorized sealing?
Mm-hmm.
Would you say that she would be entitled to sealing in the absence of a statute?
No.
Okay, so the presence of the statute matters.
Yes.
But this particular statute says we will seal some
Yes.
and not seal others.
Yes.
So does that leave you with a rational basis test as to whether or not it is rational to exclude this category of offenders? Is that the essence of what you're arguing?
It leaves the next lawyer with the next case with a rational basis challenge, because what we say is it is permissible for the government to discriminate between classes of people so long as it's not invidious and so long as it doesn't detrimentally impair a fundamental right. So in this case, what we're saying is...
But the fundamental right, you just said that there's no fundamental right to seal.
Right.
Because if there were no statute, you would not be here saying the Constitution requires there to be something akin to what in Europe they're exploring as a right to be forgotten.
Right, she doesn't have a fundamental right to seal, but she's not given a right to be heard in order to demonstrate that she should be exempted from the sealing ban against her. And the fundamental rights that are implicated by the statute are these rights that we've discussed in the brief and in the reply brief, namely essentially the right to rehabilitate, the right to find work, the right to find housing, the right to participate in one's community meaningfully and fully. Those are the rights that are disadvantaged by the application of this law. And so what we say is, when substantive due process rights are implicated by the enforcement of a state law, then the inadequacy of the process due has to be reviewed by this court under Matthews versus Eldridge, and you evaluate what is the right affected. Well, the right affected isn't the right to seal because she doesn't have a right to seal. But the deprivation of that opportunity to seal does implicate substantive important rights, and that is our argument here. It may be that that the statute is not rational. It may be that the statute is not rational because it's over-inclusive and because it includes individuals who've been found by SORB to no longer pose.
Well, so, I mean, is this essentially a rational basis as applied argument? That
Well-
it may be rational to have a statute, it may even be rational to have exclusions from the statute, but it's not rational in this circumstance.
That was our
so.
equal protection argument in the alternative. All of our arguments are as applied. As applied to this person, all the court has to look at is this person and the application of this statute to this person in the context of the absence of a hearing to be able to say, the government's interest is nowhere near compelling compared to my interests. And perhaps the government's interest is not even rational compared to
Now,
my
your sister has written, and perhaps she will say when she gets a chance, but you won't have a chance to respond unless I raise it for her, is the balance that they set in determining which exclusions they were going to make from the sealing statute were in part shaped by the recognition that employers can obtain other sources of information. They can go to all those websites, which I get emails from every day about various things, which, for the record, I do not click on.
Lucky you.
But the argument is, the legislature has said, don't worry, employer, if the person was ever a level 2, then you will know what the person's record is. And the argument that she gave in her brief is, if they can't be sure that a level 2 offender, a person ever a level 2 offender is going to be, if they're going to know of that conviction, then they're more prone to explore on their own to guard against the possibility that they'll get bitten in the rear by hiring somebody who will do something, and then they'll say you hired a person who'd been a level 2 offender. What is your response to that argument?
Well, number one is, I think that the obvious purpose of this law, it is true that the government has argued, well, at least a major purpose of this law is to kind of provide the gold standard of information to potential employers and potential landlords, and that may be true, but I think one also has to acknowledge that it's not just where the information comes from, but the anticipated use of the information. I think it is fair to say that by making this group of people unable to ever seal their records, and Christy Coe in particular, because that's who we're talking about today, the anticipated use of the unsealed records against this individual can only be for the purpose of warning people off of her. And I do think,
And is that, but let me develop that. Is that because, in view of the Superior Court decisions, the only people who were level 2 and will be no more are those who SORB found had no risk of reoffense, because that's the only basis to take them out of level 2 to no level at all?
well, they could also sort of lapse out of level 2 by operation
I
of
guess
law
that's right,
after 20
okay.
years. But I believe that the reason that this statute, the underlying grist for the mill of this statute is that these were level 2 and level 3 individuals. They no longer are, but once upon a time, somebody determined for the state of Massachusetts that they were dangerous. And that will shadow them in perpetuity in their efforts to find housing, work, and all the assets and attributes that we associate with justice.
Ms. Eisenberg, along the lines of you're not going to have a chance to respond to the Attorney General, on the Doe versus the Police Commissioner case and the 8725 case, obviously you're dealing with sex offender registry
Yes,
issues.
yes.
And the difference between the dissemination that occurs when you're dealing with sealing as opposed to level 2 and level 3 sex offenders is considerable. So you know you're going to hear that argument. Do you want to respond sort of as in advance?
I think the best answer I can give you is that if you look at the regulations of the DCJIS at 803 Code of Mass Regs, Section 205, unsealed sex offenders are available to all members of the general public. So, yes, Justice Lowy, it's true that we're not talking about affirmative dissemination, but we're also talking about unfettered availability. And I am not wise enough, and I don't have enough time to parse out the difference between the two. Thank you very much.
Thank you. Ms. Reardon, good morning.
Good morning, Your Honors. Suzanne Reardon, Assistant Attorney General on behalf of the defendants in this case. As has been discussed, the reason for the new Quarry legislation in 2010 was really twofold, as has been discussed. It was to recalibrate the balance between protecting public safety and facilitating the reintegration of criminal offenders. And the legislature made I would suggest, a rational decision to include people who have been registered as level 2 or 3 in this system. And that coincides with the fact that Ms. Coe was convicted of a sexually dangerous offense, which carries with it a lifetime registration requirement. The only reason that she was excused from sex offender registration was due to her Superior Court case in which a Superior Court judge allowed or demanded that the Sex Offender Registry Board remove her.
And no appeal was taken from that.
Correct.
So what are we supposed to do with that piece of information that you're trying to say is somehow illegitimate?
Well, we are in the position now where Ms. Coe is no longer required to register. But my point is that the legislature looked at this as a whole and made the decision that these people were something that landlords and employers should be able to see. And in fact, as has been mentioned, the substantive due process rights, I would suggest that there, as Justice Gans mentioned, there is no fundamental right to sealing. And that's really what we're talking about here. It's different than the cases such as Doe, where someone is suddenly later required to register as a sex offender when they never had been before, where it's clear that under the sex offender registry laws, they should have the opportunity to be heard before being registered. This is not a fundamental right, and the way that the legislation was set up, it gives the offenders the right to discuss their sex offense history, If an employer or landlord is going to deny housing or employment based on a criminal record, they're required to tell the person, give them a right to dispute the record, and ideally give them the right to.
I get that, but as a practical matter, as I asked earlier, what benefit is that? I mean, we kind of know that if a landlord or an employer ever finds out that somebody was once a level 2 sex offender, end of story, right? As a practical matter.
I mean, that's what the argument is. I would suggest that under this new legislative scheme, that the hope for the legislature had was that it would be different now. And they set up actually this criminal records review board so that people can bring complaints that if they were not hired due to their criminal record and they weren't given an opportunity to dispute or explain that, they can bring a claim against.
And what's the
But that doesn't
consequence?
solve the problem that Ms. Coe is talking about, though. It's a nice thing to do, but it doesn't move the needle.
And she has made claims that she hasn't received employment, but in fact, she does have housing. And she may have a fundamental liberty interest to housing, but she has it. She doesn't have a fundamental liberty interest.
You can get
to live
housing
where
in
she
her own
wants.
name, though.
Correct, but she does have housing.
Well, it's better than being homeless, but it's not the same thing as having your own place, is it?
That's true, but I don't think the fundamental liberty interest to housing includes a right to live where you want or to be your own tenant, so to speak. And in fact, Ms. Coe has said in her affidavit that she is actually running a nonprofit. So there are opportunities for employment that, I don't know, perhaps she hasn't looked for. I think if we really dig down and look at, is there a rational basis for this statute, and look at it as a whole, the legislature really did try to look at it as a whole and make it so that on the other end, employers and landlords are not allowed to ask at the outset if someone has a criminal record. They should look at the person, decide if they're going to hire them, and then look at the criminal record, and then they should be the person should be given an opportunity to.
Counsel, what about Ms. Coe's retroactivity argument?
Yes, so the retroactivity argument, I would suggest again, is a little different from the sex offender registry cases which are cited. Again, this is not a statute that attaches new legal consequences, because again, she has no right to sealing. So the fact that at the time she was convicted or was registered as a sex offender, she didn't have, again, at that time, she would have been able to seal her sex offense. That isn't a legal consequence that falls under the retroactivity analysis. And even if it does, we look at the test of reasonableness and we look at the public interest which motivated the legislature. And again, there was good reason for the legislature. They wanted their ultimate goal, or one of their ultimate goals, was that employers and landlords would go to this CORI system, and that would be their only means of accessing criminal records instead of looking at other avenues of finding perhaps inaccurate information about offenders.
Could you explain how it is? I don't really understand how it works. If a landlord turns you down and you go and you to this board and you complain, what is the consequence? I mean, what happens then? I mean, is there a consequence for the landlord who doesn't?
They can be fined, and they can be required to take more training on the new CORI laws. So there is some consequence.
But not for that person. I mean, the person doesn't necessarily get any relief from bringing this.
Not necessarily for the person, but it is.
So what motivation is there for somebody to do that then, if there's nothing to be gained by doing it for that person?
To make sure that the employers and landlords are educated on what their responsibilities are. Under
Is there any consequence with the local housing authority if you're dealing with public housing?
any consequence.
For the individual, let's say that there is discrimination as it relates to somebody who was a level 2 or level 3 sex offender, and you go before this local housing authority and you're dealing with public housing. Is there any redress going to Justice Link's question in that context or not?
For the particular person involved?
Right.
Not that I know of.
And is that a procedural due process problem?
Again, I think it's one step removed from the cases such as Doe, which involved a statute in which level 3 sex offenders were not allowed to reside in nursing homes, because that was a direct effect. It said people who are registered as level 3 may not live in these places. I think it's one step removed where you're saying they are not allowed to seal, and that in turn may have some effect, but we don't know.
Would it make a difference if she had actually shown in the record that she lost out on an employment opportunity because the employer had access to the Corey information? I mean, an employer can refuse to hire if they want to, right?
That's correct. But again, I don't know that we can link it that directly to the fact that she was not able to.
No, I mean, not this particular defendant, but suppose that there was one who could say that I lost out on a job or a housing opportunity because the landlord or the employer found out, because my record wasn't sealed, that I was once a level 2 sex offender. Would it make a difference?
It might, but again, I think the system as it's set up gives opportunities. Again, if the employer or landlord is supposed to let the person know, we are not hiring you because of this criminal offense, and they should have then the opportunity to talk about that.
But they
In
don't.
this
But they
partic-
simply could say they could simply say, we're not going to choose you.
Correct, but then we wouldn't know for sure why that was.
Right, but isn't that what 99% of employers are going to do, as opposed to saying, we're not hiring you because you have this prior sex offense, we're not going to be letting you rent the apartment because of that, we're just going to say, we've chosen somebody else. Why would they have to confront that issue? And why, so, I mean, how is she going to really know?
It's true, but again, then it becomes speculative. We don't really know, so we can't really rely on a speculation.
Well, let me ask you, first of all, is Christy Coe a pseudonym or her true name?
Pseudonym.
It's a pseudonym, okay. So, if I'm a landlord and Ms. Coe seeks to rent an apartment in my apartment complex, what do I see? Do I see anything about level 2, or do I simply say that she has a prior conviction in 26 years ago?
You see her prior conviction because she is no longer registered. as a
Okay,
sex-
so I see that. And when do I see that?
You see that after you've made a determination that she is someone you might be interested in hiring or renting an apartment to. Then you may run the query.
So basically, I say, okay, she looks like she's qualified. And then I do the query, and then I see that, and I say, oops, I don't think I want her. And then I don't rent to her. And I will never know, under those circumstances, that she has been determined to have no risk of a sexual offense, because I, of course, am not going to see the SORB finding or the Superior Court decision.
True.
So, what does that mean? She has this, I mean, you argue that she has this, she's one of the few people in the world who've been declared to be sexually non-dangerous. Few of us have such a document that says that, but what good will it do if she doesn't get a chance to show it to anybody because she's being turned down on the basis of a sex conviction, which would not generally yield that finding?
I mean, there's nothing stopping her from, at that point, telling the landlord affirmatively, I've been found to be of no risk of reoffense, where she has that actual finding from the Superior Court. I know that's not ideal, but I think if that's the concern.
That's closing the barn door after the horse is out, right?
Perhaps. I mean, I think it just really comes down to, did the legislature have a rational basis for making this determination on who would be able to seal the record, and what kind of things employers and landlords want to see?
Now, is there any reason the legislature didn't provide any means for somebody who was a level 2 offender in these circumstances to no longer be a level 2 offender, correct?
In the statute.
In the statute.
In the statute.
They, if they've been convicted of not convicted of a sexually violent offense, then they can.
Right, but if they are convicted of the particular offense for which she was, which is indecent A and B against a child, was it indecent A and B or was it rape? Was it indecent A and B?
The indecent A and B is a sexually violent offense.
Okay,
That's-
indecent A and B, then the statute provides no means for that person to not be viewed as a level 2 offender.
Correct, or a level 1.
So why would the legislature have anticipated this possibility when the legislation didn't provide for it?
I thought about this too, and I think the reason that the statute says anyone who has ever been registered as a level 2 or 3 is there are people who may have been registered at a level 2 who could have been determined no longer, if it was a non-sexually violent offense, let's say, they could have gone back to the Sex Offender Registry Board and been relieved of registration, and they wanted to catch that group of people.
Well, can't you do that even for certain offenses after 10 years?
Yes.
But I guess the problem that Chief Justice Gantz is asking about is when you look at the government interest involved in an as-applied substantive due process situation, is the government's interest different if the plaintiff here, the appellant, if they've actually been determined not to be a sexually dangerous person? There's actually a determination, put aside how it happened in the Superior Court, but there's that determination. What does that do, I guess, to the state interest?
The fact that she was determined to no longer be, I mean, I think there's slightly different interests involved in being registered as a sex offender and being able to seal your record. I think there's, as has been said, sex offender registration carries with it much more, it carries with it a possible criminal penalty if you don't register. So I think it's a little bit different, the analysis as to what sex offender registration means as opposed to what sealing means to a person.
Okay, thank you.
Thank you very much.